Yeah. Morning, councilors. Sally Garcia on behalf of Salas and Mary Law Firm, here representing the applicant and mother. I would like to ask for minutes for rebuttal. What we have here, Your Honor, is a family law case.
You just speak up just a little bit.
Is this better?
Yes.
What we have here is a family law case, but not your typical appeal family law case. We have a case where an interim order that was erroneously entered paved the way for the entry of a final judgment. For this reason, we believe that the history of this case is key in finding the error that the court committed. If we look at the history of the case, the parties entered into an agreed parenting plan back in March of 2018 that was ratified and incorporated into the final judgment. That final judgment awarded shared parental responsibility with mother having ultimate decision-making authority and gave mother 316 overnights a year. The parties abided by the final judgment until about August 13 of 2020, where the father filed an emergency motion for temporary custody of the minor children. Notably, that emergency motion did not cite any substantial change in circumstances, nor that a change in custody was in the children's best interest. The court said that motion for an expedited hearing, where the court ordered mother not to have any contact, where the court ordered for mother's boyfriend not to have any contact with the minor children. The children returned to mother's care, where at some point mother was with the children and father came across a video on Instagram of mother's boyfriend's profile and filed an emergency motion for contempt. Mother replied to that emergency motion for contempt, and the matter was set for hearing. But it wasn't set for a normal evidentiary hearing. It was set for a hearing during a case management conference, where traditionally it's not an evidentiary hearing. There is no notice of hearing on the record, so it is unclear if proper notice was provided. But the case law does indicate that whenever a case management conference is going to be used as an evidentiary hearing, it does need to be indicated in the notice of hearing.
Clarify something. The children testified the day before the case management hearing. It's just the court announced its decision at the case management hearing.
My understanding is that the children testified during the case management hearing, and the order was entered the day following the case management hearing.
Because I thought they testified on March 24th, and the hearing was on March 25th. And the court took the testimony of the children specifically at the request of the mother, who insisted that the children were in the very best position to explain what had happened.
There was a stipulation by the parties for the children to testify. My understanding is the children testified during the case management conference on March 25th, and the ruling was entered on March 26th, the following day.
But there was a stipulation.
By the parties to allow the testimony to children who were 9 and 8 years old at the time.
But still, I mean, how do we get around that to buy into your?
That's not the only evidence the church to consider, and the court did not allow mother to present any other evidence to support her position.
Well, on March 31st, the court entered an order clarifying its order on the motion for child pickup order. And the court stated that it had already heard testimony in connection with the mother's motion to vacate the 820 order at the 222 hearing, which we don't have a transcript of, right?
The only transcripts that we do have are 2 of the 3 days for trial, so no other hearings.
Okay, so there was a hearing where the mother was able to present testimony.
That was on the first emergency motion.
And that all had to do with the alleged abuse against the children.
The alleged abuse against the children, which no other professional was able to substantiate. Detailed or cold.
I understand that, but the mother, talking specifically about your due process argument, the mother did have the opportunity to present testimony going to the abuse allegations. And afterward, based on the insistence of the mother who moved to vacate the 820 order, the court then, after taking testimony from the parents, also heard again from the children. So everybody got to testify
That was,
on this particular issue.
I was not the trial attorney, so.
No, I understand that, but you and I are looking at the same record.
I understand, and my understanding is that at the hearing of the return hearing for that emergency motion filed in August, the father agreed in open court that the children should remain with the mother as long as the mother does not allow any contact between the children and the boyfriend. And that's the reason why the children remain in the care of the mother. That's my understanding.
No, I understand that too, but what I'm saying is. So you're saying that the testimony that the mom gave had to do with that original order being entered?
I don't believe the mother provided any testimony. I believe it was an agreement of the parties which the court incorporated into an order.
Okay, because there was testimony according to the order that the trial court entered on 3/31. The trial court heard testimony in connection with the mother's motion to vacate the H-20 order. So that's the H-20 order was the one that said the kids get to remain with mom unless she allows the boyfriend further access. That they heard testimony at the 2/22 hearing. So the mother apparently, according to the court's order, which is all that we can go on because we don't have the transcript, the mother did have the opportunity to present evidence to testify regarding whether the boyfriend had additional contact with the children.
Well, Your Honor, I think we're talking about different orders. I'm specifically talking about the emergency motion for contempt filed by the father on September 11, 2020.
Right, and the mother responded to that, but then withdrew her response and instead sought to vacate the original order, which is what she supposedly violated, giving rise to the contempt motion. So she wanted to go back beyond just the contempt motion and vacate the original order that gave rise to it.
And I don't see any, I'm not aware of any testimony taken. I am aware that after the court entered a ruling on March 26th of 2021 on that motion for contempt, the mother did file an emergency motion for rehearing, where she alleged that she was not allowed to present any evidence. And she had had several exhibits in there. There's also following a motion for disqualification, and there was also a motion for transfer venue. Now, none of these motions that the mother filed subsequently to that order were adjudicated. It was the following motion filed by the father for pickup order. The court did rule on the pickup order while having mother's motion for rehearing pending. So mother's motion remained outstanding, the exception of the motion for disqualification, which was denied. So in addition to this, we also see that at the time that this emergency order changing custody was entered, it was granted until further order of the court. Yet, no supplemental petition had been filed at that time. So we have a temporary order changing the custody of the kids on the further order of the court. It's our position that we didn't have the jurisdiction to grant that type of modification for several reasons. One, father did not allege a substantial change in circumstances in any of his motions. Two,
Well, that was the basis. The basis was the contempt of the court's order, where the mother had specifically agreed that if she had allowed further contact with the boyfriend, then there would be a temporary change in custody.
even if you go by that logic, Your Honor, the motion needs to be very specific. The case law is clear that whenever there's a temporary change of custody or a permanent change in custody, the court must consider a substantial change in circumstances and must make a determination of the children's best interest. Neither of those things were done here.
Those orders were not challenged on appeal, correct?
They were interim orders, so no, they were not challenged.
Trial court could have revisited those orders at any time because they were interim orders.
Upon request by motion of one of the parties. What happened afterwards was that a supplemental petition was filed. A guardian ad litem was appointed to do an investigation.
Stipulation, guardian ad litem was appointed.
Correct.
And then there was a 3-day evidentiary trial leading to the orders now on appeal.
Correct. Correct. And it's important to point out that based on the guardian's ad litem report, which is one of the very few pieces of evidence presented by the father, there was no, he couldn't support any evidence of any abuse. In fact, in his own report, on page 966, the last sentence of the partial paragraph at the beginning of the page, there is a determination or finding that the father could have coached the children. On page 70 of the final children, it does indicate that the children felt intimidated by the court. So we have all these factors coming into play that created the perfect storm for this supplemental petition to be filed, which mirrors the findings that the court made. We also have a 3-day
That
trial.
also gave excuse me, that also gave an opportunity to your client to present evidence, to challenge anything that the husband was asking for. And that led or resulted in a 3-day hearing
Is the
where all the evidence was presented.
is your Honor referring to the final hearing?
Yes,
Yes, Your Honor, we do agree that if they give mom the opportunity, and she did, she presented several pieces of evidence that supported her position. She
Which-
did.
is asking us to reweigh the evidence, which we don't get to do.
Not asking you to reweigh the evidence, asking you to find that there was a lack of substantial change in circumstances and the evidence considered by the court to support that. Father presented 3 pieces of evidence, none of which support the allegations that he raised in his supplemental petition.
The court made very specific and detailed findings as to what changes and circumstances had occurred. Is it your client's position that there is no evidence whatsoever that supports any of those findings?
During the final hearing, that is correct. It is our position that there's no evidence that support those allegations raised by the father. And father therefore wasn't able to prove his supplemental petition by the preponderance of the evidence. Even the guardian ad litem report indicates that there was no allegation raised, that there was no use of marijuana. We have DCF reports that he considered that believed that the father had coached the children. We have father's own admissions and his own transcripts that the improvement that there's no improvement in the school, the grades of the children in Arkansas.
The court's findings go to the change in the children's performance as children and students. The court made findings as to the mother's exposure of the children to inappropriate contacts, which were the subject of final court orders. The court found a substantial change included your client instructing the children to lie to the court, which the court made a finding about. I understand your client disagrees, but each of those things seem to be supported by at least some evidence from the trial.
Well, Your Honor, actually, if the court refers to the record 479, paragraph T, the court specifically said that it had the unique ability to see exactly how the children have blossomed and progressed followed their father, making reference that if this temporary change in custody had not taken place, the court would not have been able to consider what they were considering at the moment in time. In addition, it also states the children lives.
That is a challenge to the earlier order, which could have been challenged and wasn't. So doesn't the trial court, and now we have to deal with the circumstances that are set up on the table at the evidentiary hearing?
Yes, Your Honor, and even if the court considers the circumstances at the time of the final hearing, father wasn't able to show any of the allegations that he alleged in his supplemental petition. His allegation,
Don't have most of his testimony, right? We're missing a full transcript day, but it's the
we're missing the
testimony and the mom's testimony.
we're missing the second day. I believe we have about half of father's testimony. I don't believe that there has any of the mother's testimony because it took place mostly on the second day. But I do believe that what the court has available to review the record is sufficient to show that there was a lack of substantial change in circumstances and that the change in custody was not in the children's best interest. We're talking about the children who were born in Florida who have ties to Florida. And in a win, mother's time sharing was reduced from 316 overnights in a year to 66, which is also insufficient to maintain a meaningful relationship with the children.
Ms. Garcia, you're at the 5-minute mark. If you wish to reserve that time for rebuttal.
Yes, thank you, Your Honor.
Very good, thank you.
May it please the court, Daniel Smith on behalf of Kenny Land Associates on behalf of the appellee, Justin Delaware. We believe that the amended supplemental final judgment should be affirmed for a number of reasons. In regards to the former wife's, the mother's due process arguments, we believe that the August 2020 order is extremely important in establishing that she in fact set the table for all the things that happened later on in this case. Specifically, when it comes to the very specific provision that was agreed upon in open court as a part of the record that was mentioned in the amended supplemental final judgment and findings of fact, it was absolutely agreed upon by the parties that as a part of that emergency motion of order that the former husband filed back in August of 2020, that if Mr. Vega was found to have any contact with the party's minor children, that the court would immediately change the custody of the minor children until further with the court, and the court specifically maintained and reserved jurisdiction to enforce this. So there can be no argument by the former wife, the mother, that she was not given due process and sufficient notice that this was something that could have occurred. It is certainly an unusual provision, but it's something that she agreed upon, and she was represented by counsel. They actually did file a motion to vacate, and they essentially filed this motion to vacate saying that the children were going to recant their testimony. And it turns out that the children didn't do that, and that the court found that there was sufficient evidence from talking with the kids that there was contact between Mr. Vega and the minor children, and the court acted accordingly with what everyone knew was a possibility that could occur. This is something, Your Honor, that is in addition to exactly what everyone was pointed out on earlier argument, which is that there was also the opportunity for the mother to put on evidence at the February 2021 hearing. She had the ability to put on evidence, and then by stipulation of the parties agreed that the minor children should be allowed to testify to essentially say their piece. And it was in an hour hearing, not attended by either counsel or a party, and the court acted in every step of this in accordance with stipulations of the parties and the agreement of the parties. And so we believe that this is something, Your Honor, that is a situation where mother had the opportunity at all times to assert her rights, to be able to establish what she believed to be, what she believed to be her version of the facts, and the court did not abuse its discretion and finding that the court didn't agree with her position on things. And because of that, Your Honor, we believe that this is a situation where this must be affirmed. In terms of the relocation piece, it looks like this was not something that had been mentioned too much. So I would rely on my brief in terms of the relocation arguments. And then for the substantial change in circumstances, I would say that there was 3 days of testimony, 3 days of trial work here, and in the absence of a trial transcript here, the court must rely on the substantial findings of the lower court in terms of making a decision as to whether or not there was an abuse of discretion. And the final judgment and the findings related therein, it's 13 pages long. It is extremely comprehensive in terms of what Judge Pohl found after this 3-day trial here. And the fact that there was only 3 pieces of quote unquote of evidence does not disregard the fact that there was 3 days of testimony, which is in and of itself obviously evidence. And the court was well within its grounds to be able to find accordingly for the former husband. So because of this, we believe that this court should affirm the lower court's ruling, affirm the amended supplemental final judgment, and respectfully, if there are no questions, Your Honor, I would yield the rest of my time and rely on the verdict.
Very good. Thank you, Mr. Smith.
Thank you very much.
Ms. Garcia.
I think that we have been hearing throughout this case, not just in lower trial court or here in this appeal case, is that the mother is at fault. Father continuously continues to throw the burden on the mother, which is the other way around. It is the father's burden to show by clear and convincing proponents of the evidence that there had been a substantial change in circumstances. In regards to the order entered in August 20th, 2020, and the subsequent motion filed for contempt, which the court granted and ordered the children to go into the custody of the father. There was substantial case law cited in our brief that indicates that change in custody is not a proper sanction for a contempt. And that is exactly what the lower trial court did here. Had that not changed in circumstances, apologies. Had that order not been granted, father would not have filed a supplemental petition. If we look at the record, we have the order changing the custody, we have the pickup order giving custody of the children to the father, we have father picking up the children, and a month later, father filed a supplemental petition to modify, citing exactly the same findings that the court made. We have a continuous history from the lower court ignoring mother's motion for rehearing, ignoring mother's motion for disqualification, ignoring motions filed by the mother, not adjudicating them at all. But yet we have father's motions that were quickly adjudicated. We see that the evidence that was introduced supporting the factors that the court needs to consider, whether there has been a substantial change in circumstances or not, do not support the father's position. But the evidence presented from the mother does support the mother's position. For these reasons, we do believe that the court should remand the case back to lower court, and that the children, that the party should be continue to follow the originally entered parenting plan prior to its medication. Thank you.
Thank you, Brian. The next case on the docket is Wallace versus Department of Transportation and CF 41 sections.